Good evening. I want to welcome everyone here tonight. This is, I think, a long time in the making, and we just wanted to make sure that everyone was here to get information that you need. I am Delegate Cia Price, and I have the honor of representing the 95th House District, which is parts of Newport News and Hampton. And you don't have to be from the 95th district to be here this evening, but I represent two of the locations that the evictions lab data shows have the highest number of evictions. And I serve on, 4 committees and 5 subcommittees, one of which is the Housing and Consumer Protection Subcommittee. And so we deal with housing legislation. And so on that committee, and so for few years now, I've been working on the issue of housing based on hearing directly from constituents in the experiences that they've been having. And so in that work, I have found few organizations that work as hard for tenants than the Virginia Poverty Law Center. So I'm glad to have them here with us this evening. And they will be the ones sharing the main information in just a few, and we'll work to get all of your questions answered at the end. I also have my Chief of Staff, Tempest Boone, who's here, and she'll be managing the chat feature. So if you have any questions, please type them in the chat, and we'll, like I said, get as many as possible answered today. Some of your questions might have us needing to look up some things, so we will get back to you, but we'll make sure that you have our contact information, we have your email address, but we just want to make sure that everybody leaves with their answers, or at least a connection to how to get answers. We are recording this evening's conversation, but part of that recording does not include the chat, so that will not be public. And if you want to send your question directly to Tempest, you can do that in the chat feature, or you can send it to everyone. But tonight we're going to talk about a little bit of the progress that we've made in improving the equity of the tenant and landlord relationship, offering more information, transparency, and protections to tenants. And this is really important for my district because I know that there are some landlords that are choosing to not do the right thing. And so those protections are sorely needed. But a lot of those bills passed even before the pandemic hit. And so we'll also go over some information that contains resources and really important things that you need to know as a tenant, as a head of an organization that works with tenants, or just as someone that wants to know about how Virginia laws really impact the actual lives of constituents. We'll go over some of those resources that are kind of COVID specific. But just to give you an example of why it's important that we hear from your experiences, in summer of 2018, I was called out to a complex that was experiencing a lot of need for repairs, but specifically for air conditioning. And we have been working ever since then to make sure that the local, state, and federal levels are all responding, not just to that one complex, but for tenants all across the Commonwealth. But prior to hearing about the situation in this complex, there was a regulation that stated that landlords only had to cool a room to 80 degrees in order to fulfill the requirement of providing cooling. And I don't know if you've been in a room that was 80 degrees, but I would not consider that to be cooling under any of the definitions. And so one of the things that we've been able to do from a statewide perspective was get an emergency regulation in place that said that if you say that you offer cooling, you have to cool rooms to at most 77 degrees. Now that may sound small, but that is a big difference when you are sitting in your living room just trying to exist, right? And so, so it's these things that once we hear about the issues, once we learn about the problems, we can work to make corrections. And that emergency regulation is well on its way to becoming a permanent regulation. We were also able to pass House Bill 340, which you will hear more about this evening, but it helps tenants have 60 days longer before an eviction proceeds if they've lost income due to a federal furlough or because of loss of income due to COVID-19. And we also reached out to the Attorney General to help us understand the full realm of actions that all 3 branches of government can do to help people stay in their homes. And so we'll hear more about that because it's really important. You know, I think the most aggravating thing is to know that we're under a safer at home or a shelter at home order, but we're actively kicking people out of their homes during this pandemic. And so kind of bifurcated, we understand that there needs to be fixes to the housing system in general, but there are also some more immediate concerns right now in trying to keep people in their homes for the pandemic. So I say all of this to let you know that there are people working to fix the systems that are broken, and your presence here tonight helps us get this information out, but it also helps hear more about the issues that you're experiencing so we know even more about what needs to be fixed going forward. So thank you again for being here this evening, and I'm gonna now turn it over to Christy and her team with the Virginia Poverty Law Center. And so Christy, give me 1 second and I will unmute you. I know that Laura has been unmuted, and get Daryl unmuted. And maybe it's Daryl and Laura right now.
I think I'm unmuted right now for sure. Is Christy still?
I think Christy might have had some issues. She might be on her way back.
Okay. Well, in any event, how
I can go and start off.
Yeah.
So we're going to go over, I see Delegate Price mentioned the eviction process, some tenant protections that are in place. Some of those including the rent relief program going on right now, and upcoming in Hampton that start on July 1st is a pilot eviction diversion program, a few of the new housing laws, and then we'll open up for a more broader discussion. So I just wanted to give a brief overview of what we're looking at. So in 2018, the Eviction Lab came out with a study studying evictions across the country, and it found that cities in Virginia had some of the highest eviction rates in the country. Richmond had the highest second eviction rate in the country among large cities. Hampton had the third highest eviction rate, Newport News fourth, Norfolk sixth, and Chesapeake 10th. So this is obviously very alarming and disturbing. And I just, have some of the numbers for Newport News and Hampton, and this is looking at evictions from 2016. So 2016 in Newport News, there were 10.2 evictions per day, and very significantly higher than the national US average among eviction rates. And this is important to keep in mind that roughly 50% of homes in Newport News are renters, and that 30% of those people are rent burdened. Pretty much every guidance out there that says that you should not be paying any more than 30% of your income towards rent, and anything more that can make it lead to a really unstable housing situation, to where if you have a medical emergency or you reduced hours in work, it makes it really hard to keep up to date on your rent, and it creates this cycle of a problem. But we've been working since then, working with delegates as well as a lot of the professional landlords who are also interested in fixing this problem, to come up with solutions to help people. And I'm just going to turn it over to Daryl just to give a brief overview of the eviction process, and then we'll go deeper dive into some of those protections that are in place right now.
Thank you, Laura. Hello, my name is Daryl Hayat. I'm an attorney with the Virginia Poverty Law Center. I'm a housing attorney. And I just want to briefly go over the process of eviction, some things under the law that you could take advantage of, and just so you can get an outline of the rights and responsibilities of both the landlord and the tenant. So starting with these three things under Virginia law that are always true. Number one, your landlord cannot cut off your utilities, lock you out, or take other actions to deny you free use and enjoyment of your home. This is something called self-help eviction. And this is something that is illegal in Virginia. And you definitely want to be mindful of that. Our office gets calls a lot of times where landlords are putting stuff out in the street or cutting off electricity and doing other things that is disadvantageous to your living environment. So if that's the case, that's actually a form of an illegal eviction, and there's a civil remedy for that. The second is you do not have to move out just because your landlord tells you to leave or files an eviction case against you. And I'll get into this in the later slides, but there's a whole process that a landlord must go through when they're trying to evict you. It has numerous steps, and until that last prong is filled, you can't, and only the sheriff can kick you out. So that's a whole process that we'll get into a little later. And third, your landlord must wait until he wins in court and the sheriff has the writ to evict you. So, after he wins in court, after that 10 days of appeal, he'll have to go up, and I'll explain that later, but that the complete eviction process has to be done, or the eviction is illegal. Next slide. So this is the eviction process in Virginia. We're going to start to get into that. Now, your landlord cannot evict you without a court order, no matter what your lease says. And this is important because your landlord, or whomever is in charge of getting these leases out, they're drafting this lease. They're putting the language in there, and they can put whatever they want to put in there, really. And if you're hard up to get into that unit, in that place, you may not read everything, and it may have some language that may, make it so that it gives him some, him or her some extra liberties when it comes down to eviction. Well, no matter what the lease says, he still has to go through the court process. You do not have to move out because your landlord tells you to leave, gives you a written pay or quit notice, which is the first notice that you're supposed to get. It'll be from that landlord and not from the court. Has you served with a summons for unlawful detainer, or has you served with a writ of eviction by the sheriff. So if any of these things are preempted by an eviction from your landlord, you might be able to get help to fight your eviction. Of course, it depends on the facts of the case, and only an attorney can tell you for sure. The earlier in the process you learn about your rights and options, the better chance you have to avoid eviction. And we have 2 phone numbers on the bottom of this slide that you can take advantage of if you need any assistance or you have any questions pertaining to eviction. The first is what I feel is the most important number, 1-833-NO-EVICT. This is an eviction helpline that started by a fantastic lawyer named Phil Story here at the Virginia Poverty Law Center. Both Laura and I volunteer on this helpline. And if you're pending eviction, if it's crunch time, or if you just have some general questions, we're more than happy to help you. Also, the general legal aid number is also here. That's 1-866-534-4243. All right. And we're going to take you through the yellow brick road of eviction. This is the eviction process in Virginia. So like I mentioned before, it has multiple steps, and you have to go through all these steps in order for this to be an actual legal eviction. The first is a notice of default of termination. Before filing in court, the landlord must give you written notice of the lease termination. It usually gives 5 days for unpaid rent or a 30-day warning. Now, this is what's called a 5-day pay or quit notice. So just taking you through, say the first comes and you can't pay your rent. Well, the 1st through the 5th is a grace period. That's everywhere. You can wait until the 5th to pay your rent every month, completely legal. If you wait till after the 5th, now here comes this first letter saying, hey, you still owe us some rent. We're going to give you an extra 5 days. The 30-day warning typically is around, has to do with breaches of the lease that doesn't have anything to do with money. So the next step, if you get past those 5 days and you still can't pay, then the landlord sues and you will receive a summons. The summons comes from the court. It gives you the date, time, and the location of the hearing of the unlawful detainer. So the unlawful detainer is a term that just means there's an eviction case. Okay, and so you'll get your summons. It'll have the date. Usually about 3 weeks after you get the summons, you'll have to appear in court. And on that court date, you must go to court if you want to fight your case. Now, this is very, very critical because, and as Laura can attest to, there's been plenty of times where she and I have sat up in the court, Laura most recently, and people just lose their cases because they're not showing up. You always want to make sure that you show up for court. If it's only for unpaid rent, you might have the right to pay and everything. You may have the right to pay everything by the court date and avoid a judgment. This is called redemption. And so if you pay everything and you pay all your fees and penalties, then you can redeem, meaning that you won't be kicked out of your home. But you also have to be critical of the fact that you could only redeem once every 12 months. So you don't want to find yourself in this position more than once. Also note that by this third point here, it's gotten a little bit more expensive. You have some court costs that have piled up, and of course you have some penalties from your landlord, like some late penalties, which are capped at 10% now, but it still will accrue. So after the court date, if things don't go your way, you'll get that judgment for possession. If the judge rules for the landlord, they get a judgment for possession. This means they could take the next steps to evict you. Doesn't mean you have to move out yet, okay? Because you still have the appeal period. So after a judgment, you have 10 days to appeal. And that time, you will need to file appeal papers and pay the court all rent owed and amount the judge will set. Now, as you notice, as you go down this yellow brick road, it's getting more and more expensive because now you have to pay for the appeal, you still have to pay your back rent, you have to pay your charges. So it doesn't help to be late, but it's a process that we have to go by. So after that 10 days of appeal, nothing goes your way, then the next step is a writ of eviction. After getting the judgment for possession, the landlord asks the court for a writ of eviction and then instructs the sheriff to schedule the eviction. Now, you still have time to pay all of your rent. Even with the sheriff getting this news, you can still redeem up to 48 hours until the sheriff arrives. But it's going to get expensive. Soon after receiving the rent, the sheriff will give you a copy and a notice with a date and time they will return to evict you. This happens at least 72 hours before the eviction. Up until 2 business days, as I just mentioned, before the scheduled eviction, you might have the right to pay everything you owe and stay in your home. But if that does not happen, then the final step here, the eviction by the sheriff, unless the court or landlord cancels the eviction, the sheriff will return on the date and time on the notice to physically remove you and have the locks changed. So we definitely don't want to have you in that situation. But look at this slide, because this is important, because this is at least a 40-day process. A lot of times you'll get that 5-day pay or quit, or you just may get a text message from your landlord saying, hey, I want you out by Saturday. But you have to remember this map here, because unless this whole map is filled out and you're a legal tenant there, it's an illegal eviction.
So I'm going to talk about some of the protections that are in place to help people. We know a lot of you are struggling right now of either having lost their job or a reduction in hours that's making it difficult to pay rent. In late March of this year, Congress passed the Coronavirus Aid, Relief, and Economic Security Act. And it does several things. That's where the stimulus checks came from, but it also provides relief to both tenants and homeowners. And so as it applies to tenants, so under the CARES Act, certain landlords are prohibited from charging any late fees for late or unpaid rent. And they cannot begin evictions against tenants for unpaid rent until after July 25th, which is Saturday. And then even after that, they have to give tenants a 30-day notice before beginning that eviction case. As Daryl mentioned, typically it's just a 5-day notice. But Congress understands it's probably going to take people time to get the funds together to pay whatever they've missed during the coronavirus. And so they're requiring that 30-day notice before the landlord can file the eviction case. Now this, it only applies if the reason for the eviction was because of unpaid rent or fees. So if your housing is covered by the CARES Act, as I mentioned, your landlord cannot charge you late fees or begin that eviction case against you for unpaid rent. Keeping in mind that in Virginia, rent is very broadly defined. So if it's, any damages are considered rent under the VRLT, which is the Virginia Landlord Tenant Act. So anything that encompasses that would be considered unpaid rent. Now, if the eviction is for any other reason, so some other lease violation, the landlord can still move forward and evict you. And it only applies to certain types of housing. Between a fourth and a third of properties across the US are covered by this. So it covers subsidized housing. This includes any Section 8 voucher holders, Section 8 project-based housing, your traditional public housing, HUD senior housing, or tax credit property called LIHTC, low income housing tax credit housing. And it applies to certain private, non-subsidized housing where the landlord has a federally backed mortgage. This would be any mortgage that's from HUD, including FHA loans, if they have a USDA mortgage, if they have a VA loan, or a Fannie Mae or Freddie Mac mortgage. And we understand most tenants don't have this information, but there is a lookup tool if you live in a multifamily property. But if you live in a single family home, if you get sued by your landlord, whenever you go to court, just request the judge, just explain to the judge, I don't know if my property is covered by the CARES Act, and ask the judge to require the landlord to prove that they're not covered. So in Newport News and Hampton, there's a bunch of CARES Act covered properties. I didn't list all of them. This is just a handful here. I'll point out a few like Aqua Vista Apartments, Ash Manor, Brennan Point, Derby Run, Ivy Tower, Heritage Forest, Marshall Courts, Medical Arts Seniors, Newport Harbor Apartments, Stewart Gardens, Waterford Point, but there's a bunch more. And if you look at the slide, there's 2 links that you can use to look up your property if you live in multifamily housing, so any apartment complex. The first one is a tool from ProPublica where you can just type in your address and it'll pull up and you can find if you're covered. Another one was put together by the National Low Income Housing Project. And there, it's a bit glitchier tool, and I usually just try to look it up by zip code. But if for whatever reason one isn't working, you have the other available as well to try to find if your property is covered. And then something else available for people right now is a 60-day continuance. This is something that your delegate price put forward. Initially, it applied to anyone who's employee or contract employee of a federal government and has lost income due to a government shutdown. But shortly after session ended, COVID-19 happened, and everyone very quickly realized that people are going to be in a crunch trying to pay their rent if they're losing income due to this virus. So you could be eligible to delay your case under this new state law. So there's 3 things you need to do. First, it only applies if you've lost income due to COVID-19. This could even be if you just had, a reduction in hours that makes it difficult to, pay all of your rent. And you have to have your court date for your eviction case scheduled before the end of this COVID-19 emergency. So this is still available right now. We're still under the emergency. And so if both of those things are true, you might be able to get the 60-day delay. Now you will have to bring a few things with you. First, you'll have to show up to your first court date. So as Daryl mentioned, if you're getting sued for an eviction, you'll have that summons from the court. I'm going to have the date and time. Now, if your case was previously scheduled during the judicial emergency and the courts were closed, they should be rescheduling those cases now. So if you have a question, if you think you're not sure when your case is going to be heard, just call the court or the clerk to find out when that's going to happen. And then you want to bring written proof that you've lost income. This could be if you have a pay stub showing $0, if you have a furlough letter from your employer, a letter stating that you're not essential. You could also try, some courts are accepting an affidavit that you sign saying that you've lost wages during this period. We understand that some people might be self-employed and might not have an employer letter they could bring. But I will note that not all judges are accepting this. It's sort of a case-by-case basis. So if you have questions, if you don't have any of these type of letters and questions, you should definitely reach out to an attorney, and we'll try to come up with options that might be acceptable by the judge in your jurisdiction. And then once you are in court, you want to ask that judge for a 60-day continuance of your case. Now, you still have to pay. It doesn't get rid of the eviction case. It'll still happen 60 days later. It's just giving you more time to try to access some of the other tools available right now. We now have rent relief funds that you can take advantage of. If you're in Hampton, you can try to save up money to participate in the Eviction Diversion program. So this is just to afford people more time to get back on their feet. Another thing that recently went into effect at the very end of June, also part of the CARES Act, was a bunch of funding to help people with rent relief. So Virginia has dedicated $50 million in rent and mortgage relief. It's supposed to support and ensure housing stability during this pandemic. And so depending on how much funds are available, what the household needs are, you might be able to get some financial assistance. And this applies both for renters, but also homeowners who might need help making their mortgage payments. And so it would apply to any rent and mortgage payments that were past due beginning April 1st and moving forward. So it's not going to apply if you weren't able to pay, your March or February or January rent. It would be anytime after that. And this is a one-time payment that could be renewed based on any available funding, as well as if there's any need for additional assistance or continued eligibility. So if I'm just going to talk about the rent relief part. If you have questions about getting help with mortgage payments, it might be a little bit different. And you can visit this website from DHCD, which is the Department of Housing and Community Development, that's helping get this program out there to check for your eligibility. That would be dhcd.virginia.gov/eligibility. So to find out if you meet these basic requirements, and then it'll help refer you to the local program that is administering those funds. So to be eligible, you have to have a valid lease or mortgage statement or other document showing that you have a landlord-tenant relationship. And you have to show that you lost income due to COVID-19. So similar to that 60-day continuance, they will probably require you to bring some sort of documentation, like a letter from your employer saying that your hours been cut in half, or saying that you've been furloughed due to COVID-19. And then you also have to have a monthly rent that's at or below 150% of fair market rent. So if you aren't sure about that, visit this website, type in your rent amount, and they'll tell you if you are within that threshold. And it only applies to certain low-income people. So if your gross household monthly income is at or below 80% of area median income. At first, they were prioritizing people at 80% or below of area median income, but as of this week, they're widening that net to more people. Again, if you have questions about where your income fits into that, visit that website, and it'll help you find out if you meet those basic eligibility requirements. And so there's a few different options under here. I know I said I wouldn't mention a mortgage, but I will briefly say that homeowners can receive financial assistance for mortgage payments, as I mentioned, anything due past April 1st onward. Now this is one-time payment, could be renewed, but you'll have to continue to update your current income to see if you're still eligible. And for those who are renters, you can either get a rent relief that pays 1 month of the current rent and up to 3 months of past due rent, with the landlord forgiving an equal number of months of unpaid past due bills, including rents and any late fees that you've had. Or you can get rent relief that pays for 1 month of any current rents, up to 1 month of past due rent, and the landlord agrees to get into a payment plan with you for up to 6 months for any of the remainder that you owe. Both of these options are completely voluntary with the landlord, so the landlord has to agree that they're going to accept these funds. Otherwise, you might not qualify for the program because the funds go directly to the landlord, they don't go directly to the tenant. So who do you contact? These are the local program administrators in your area. So if you're in Hampton, Newport News, or Proclassant, it would be the United Way of Greater Williamsburg. And that phone number is 757-247-0379. And I have a couple other localities in the Tidewater region listed here. But if you're in Newport News, Hampton, it would be the United Way of Greater Williamsburg who is administering that program. Another thing that is not available as of July 1st of 2020 is an eviction diversion pilot program. So in response to the high eviction rates, the General Assembly in 2019, I believe, or maybe it was 2018, passed legislation to try out something to help people who have an eviction case. And so starting July 1st, the first 5 cities are going to start off testing out this program. And Hampton is one of the locations that was selected to try this given their high eviction rate. So if you're in Hampton, you're getting sued for an eviction, you'll have the option to avoid an eviction judgment and get into a payment plan with your landlord. In order to participate, you have to follow 3 basic rules. The first is that the eviction is related to non-payment of rent only. It can't be, some other lease violation tied up in this as well. It has to be just about the failure to pay rent. And you and your landlord have to agree on the amount that you owe. So if your landlord is saying you owe $800 and you think you only owe $400, you're not going to be able to participate in the program because you're going to have to come to agreement how much you owe and how much you're going to make, what payments you're going to make up any unpaid rent. And you have to be prepared on your return date for your eviction case to make a down payment of at least 25% of the amount that's due. So you can't just show up to court the day of and say like, oh, I want to participate in the program, because if you don't have the funds available at that time, you can't participate. So it does require you to make sure you have at least some saved up to make an initial payment of 25% of what you owe. And so to participate, there's a few technical requirements that happen. First, you have to testify to the judge that you have sufficient amount of money to make these payments under the payment plan. They don't want to set you up to fail to where, you might think you have enough for that first court date, but that's going to be difficult down the road. They want to make sure it's something that you can really stick to. You have to testify as to why you fell behind on rent. Right now, if you've lost income to COVID-19, that's a very good reason. Or if you've had some sort of medical emergency, the judge just wants to have a better understanding of, why you're in the situation. And you can't have been late for rent more than 2 times in a 6-month period or more than 3 times in a 12-month period. So that if you've been repeatedly late on rent, you're not going to qualify for the program. And lastly, you can't have used your right of redemption, basically where you had an eviction case, but you paid everything you owed at the court date or before then and had that dismissed within the last 6 months. So if you've already tried to, use that right of redemption to pay and stay, you're not going to qualify. Now, one caveat to the caveat there is that this is, forward-looking. So if you've used that right of redemption in the first 6 months of this year, and now you want to participate, you still can, because they understand that no one be expected to understand about this exception for a program that didn't yet exist. So if you're in that situation, explain that to the judge or, talk to an attorney and they can talk about that technical aspect with you. And so it has certain terms under that payment plan. You have to pay by a cashier's check, certified check, or a money order. You can't pay with cash, can't pay with a credit card. You're making those payments directly to the landlord. And the landlord has to receive that payment on or before the 5th of the month. This plan. So just like rent, that extra payment would be due, due on the 1st, late after the 5th. And so that first payment, when you show up to court, you pay the 25%. Once you get into your payment plan, the following month, you pay 25%. And that month following the court date, then that other payment would be another 25%. And the last payment, the last 25% to pay everything off. So it gives you, basically 4 months, from the first court date, then the subsequently 3 months after your court date to pay off what you owe. And you will still have to pay any ongoing rent that you have. So this is an amount on top of your existing rental payments. And I'm going to turn it back over to Daryl to talk about a few other new laws passed to help tenants, as well as other things to keep in mind in your landlord-tenant relationship.
Thank you, Laura. So I just want to briefly go over some of the new laws that went into effect this year. And I think that the delegates and everybody on Capitol Hill worked so hard to try to get these things done, and I was so impressed by my time in Capitol Hill. The first major change is this limit on late fees. Your landlord is limited in the amount of late fees for late and unpaid rent that they charge you. So in the past, this late fee was only supposed to be quote unquote reasonable. So it was no actual amount that the landlord was required or like a max cap. So it could fluctuate. And like Laura said, from judge to judge, things could really change, depending on the judge that you have. So starting April 22nd, late fees are capped at either 10% of the rent amount or 10% of the amount you owe your landlord, whichever is less. Your landlord can only charge you late fees if your written lease agreement allows, and for covered properties that are covered under the CARES Act, the landlord cannot charge late fees, penalties, or other charges related to the non-payment of rent. This is for, this is in direct reaction to the COVID crisis, the third one. But the first two weren't. Then the second, ban on source of funds discrimination. Starting July 1st, 2020, sources of funds will be added to the reasons why a person may not be denied housing under the Virginia Fair Housing Law. This is very important, especially for low income or residents of Virginia that are taking government subsidies, maybe like take Section 8s and vouchers. And a potential landlord may see that you're getting some kind of government assistance and say, hey, I don't want that person, in my neighborhood, because they may judge you off where you get your funds from. So the General Assembly worked hard to try to get that this ban put in place. This protects prospective home buyers and renters. And the definition of source of funds right here is any source that lawfully provides funds to or on behalf of a renter or buyer of housing, including any assistance, benefit, or subsidy program, whether such program is administered by a governmental or non-governmental entity. So this is very important because just because people want to help you out doesn't mean that you shouldn't have housing. All right, exceptions to this source of funds protections, though. Of course, there's always caveats in law, and so this is no exception. So first, this does not apply to owners of 4 or fewer rental units in Virginia, or those who own a 10% or less interest in 4 or more units. So this is a carve out to protect kind of the smaller up and coming landlords who may not have that much capital and that much, property, or someone who is, who's in a conglomerate that has, little interest. If this does not apply if the source of funds is not approved within 15 days of submitting the request to approve the tenancy. Now this becomes a little tricky because yes, you are now relying on a third party to approve your source of funds, and with everybody working remotely and things of that nature, this may be a hurdle. So hopefully you can get this done in a timely fashion. And it's important to note that HUD has temporarily waived inspection requirements for the Section 8 voucher program. So this should, relax things. You don't have to take any other, additional steps to get your voucher inspected and approved.
Yeah, and just a quick note on that. So if you're someone who has a Section 8 voucher and you're trying to find a new place to live or moving into a new place, this waiver basically says that you can self-certify that the conditions are livable instead of having to wait for an inspector to come out to view the property. This is meant to help people get into homes as quickly as possible, as well as limit the spread of COVID.
Great point. Thank you. Statement of tenant rights and responsibilities. This is also a favorite of mine. Landlords, public and private, must offer prospective tenants a statement of tenants' rights and responsibilities that will contain the telephone number and website of the statewide legal aid organization. This is a really important law because the landlord-tenant relationship is so vital. It's so important, but little or no one, especially tenants, especially on the tenant side, knows too much about the rights and responsibilities of both the landlord and tenant. So this is great for them to be able to put that right onto a document for you. It also gives that phone number, if you need help. The statement will be available on the Department of Housing and Community Development website, the DHCD, and the statement must be signed by the landlord and tenant. The landlord may not sue the tenant in court for any reason unless the statement has been signed. So it's just like a meeting of the minds where everybody is supposed to be on the same page. And what to do if your landlord illegally evicts you. So this happens a lot more than we want it to. So if your landlord locks you out or cuts off your heat, water, gas, or electricity, I've had phone calls about all of these, then you call your sheriff's office, call your local sheriff's office or police if you feel comfortable doing so to get help getting back into your property. Then the next step is to file a lawsuit against your landlord called the Tenants Petition for Relief from Unlawful Exclusion. Now, keep in mind a couple of things about this particular slide. This filing of the lawsuit doesn't really equal to immediate relief for you. You still have to go to court. It still may take a while to get into the court, especially now with everything happening with COVID and all these social distancing requirements and the backlog from the courts. So it's important that if you find yourself in this situation and you don't have any place to stay and you have to go into a hotel or a motel or something in order to seek shelter, make sure you keep all your receipts and keep everything that you paid out of pocket for being, out of your home. And that way you can seek, compensation on your court date for that unlawful exclusion.
And I just want to make a quick note regarding the utilities. There's a moratorium put on utility shutoffs for non-payments that have been extended through August, and our understanding is Dominion is extending that into October. So if your utility gets cut off and you haven't paid the bills, it's probably not the utility company. It's likely your landlord who did that because utilities understand the necessity to have access to electricity and water in order to keep everyone healthy and safe. And lastly, the tenants petitioned for relief from unlawful exclusion, which is quite the mouthful, can be a little bit confusing, but on our website, we have a toolkit to help walk you through that process. It explains how to fill out the form, where to go, and what those steps are to guide you. And at the end of the PowerPoint, we'll have a link to our website to where you can access and other COVID-related resources.
Thank you so much, Laura, for that. Moving forward to evictions from hotels and motels, something else that Laura and I often see. So the hotels and motels, if you're living in a hotel and motel, you may or may not be covered under the VRLTA, the Virginia Residential Landlord Tenant Act, depending on how many days you've already been there. So if you lived in a hotel or motel for more than 90 days, you are a tenant, and the hotel owner or manager cannot evict you without taking you to court and getting a court order. So, after 90 days, you are considered an official tenant. Now, we're going to be trying to work hard to try to get that shortened up because we know that people really need some safety. But if you are a tenant that is living in, then the live-in means that it is your only home. And if you are a tenant that has been living there less than 90 days, then you may find yourself, the landlords can take self-help remedies, which is them taking your stuff and taking it out or changing the locks on you. If you are a tenant that's lived over 90 days in the hotel or motel, the landlord must give you a 5-day pay or quit notice, just the same as a regular tenant. And he has to take you to court and do the whole process that we went over a little bit earlier. If you've lived in a hotel or a motel for less than 90 days, like I mentioned, they could rekey the door. But if the eviction is not for paying the rent, they must give you a written notice of 5 days before evicting you.
And I just want to interject here. We really are working to try to get, at least for the duration of the state of emergency and for 90 days afterwards, everybody who is living in a hotel or motel treated as a tenant with the right to due process and the right to the notice and the opportunity to go to court. So if anybody is hearing about people experiencing the problem that Daryl just described, getting put out of the hotel where they've been living for weeks and weeks and weeks without any sort of notice, please let us know, because we are looking for those stories to share with Delegate Price's colleagues in the legislature.
Absolutely. Thank you so much for that, Christine. Staying after the lease ends. All right, so this is happening a lot, and this probably will be happening a lot more. Unfortunately, because people want shelter and they should have that. But say your lease expires or someone wants you out and you have to stay, this is your only form of shelter, then you and your landlord can agree to extend your lease until a date after it is scheduled to end. Make sure you get any agreement to extend your lease in writing, and that agreement will take precedent over your current lease. If your landlord agrees to let you stay, but doesn't give you a new written lease, the terms of the lease that expired still apply, but your landlord can charge you a different rent amount if he gives you 30 days notice, at least 30 days notice if he's going to change the rent amount. If you remain in your rental home after your lease expired without an agreement from your landlord, the landlord must go through the usual process to evict you. Now, this happens a lot. I get calls, Mr. Darrell, my landlord wants me out by Sunday, wants me out by Monday, the lease is up and wants me out. And I say, look, he still has to go through the whole process. Unfortunately, you have more time than what he wants. And I know there's some landlords that want that quick turnover, but they have to abide by Virginia law. If your landlord doesn't say anything about letting you stay, but continues to accept rent from you after your lease ends, you might have the right to remain in your home, depending on whether your landlord accepted your payments with reservation or without reservation. The reservation to without reservation is basically he can accept your rent with the reservation saying he still reserves the right to evict you because you breached the lease. So you want to make sure that if you have a situation like this, that you get something in writing saying that he's going to accept this, and that this new agreement takes precedent over your current agreement. It's important to get that express language in whatever document you two are signing. Okay, repairs and maintenance during COVID-19 is also something that pops up a lot. So even in the midst of the COVID-19 pandemic, your landlord must provide you with a safe and healthy place to live. If something breaks, send a letter to your landlord asking for repairs right away. We get a lot of excuses. People say, hey, this is broke, but my landlord says that he can't get there because of social distancing and it's going to take 40 days or some other unreasonable time. So you have to make sure that you're staying diligent in trying to get this resolved as quickly as possible. If it's taking 40 days, then that's unreasonable. In an emergency situation, it should be much, much faster. If it's flooding, things of that nature, it should be next day, 24, 48 hours if it's an emergency. If it's something that's not an emergency, most courts deem something reasonable to be about like 28 days. But there's no extension on this courtesy just because of COVID. So anyway, your landlord also has the right to enter your home to make emergency repairs, even without your consent. Any emergency is anything that can cause you harm if not fixed, such as a gas leak. Also things like flooding. Be aware that these things are considered emergencies, even if they aren't typically emergencies to you. But things like flooding, things like gas leaks can have a prolonged health effect that could last for years and years, and you may not even know that you're facing these type of concerns. So just be very careful of that. You have the right to refuse entry to your landlord for non-emergency maintenance if your refusal is reasonable. So you can't not let your landlord in just because you don't like them. And I know, and that happens a lot where people have other social issues, but the landlord-tenant relationship is a professional relationship, and we have to go ahead and maintain that. So we have to try to be as reasonable as possible, and both sides have to work to help each other out.
And to add on to that, we've heard concerns from people who are concerned about getting COVID or might be immunocompromised at a point when their landlord is coming in to show the property to other people. And what we've suggested in situations is to work with your landlord and maybe suggest, like, I'm okay with you coming at a certain time to do like a video tour of the property, but, due to, whatever conditions, I don't feel comfortable having strangers come into my home. So that's definitely something you can work out with your landlord to make sure that, they can still have the property seen by other people while you still being able to stay safe.
Absolutely. Absolutely. All right. And I believe I'm going to be turning this back over to Christy, if she's on.
I am on.
Yes.
I am on, and I know we've had a number of questions come up in the chat, which is great. And Delegate Price and I have been trying to answer those questions, but I'm sure that I at least have left some unanswered, and there may be some we want to go over again so that everybody gets the benefit of them. So I don't know the best way for us to do that. I know there was just a long question put in, and it looks as if there is a question about the conditions in the home. And there are a couple of different ways to deal with that. So the first is something we call a tenant's assertion. It does have some sort of, I won't say onerous, but it has some prerequisites. So if you have a pest infestation, or you have a water leak, or you have any of these other problems that affect health and safety, what the law tells you to do is to send something in writing to your landlord, explaining the problem and asking the landlord to fix it, and giving the landlord a deadline. So if it's something that affects health and safety, like a water leak or a roach infestation, you can say, I need you to fix this within the next 2 days.
Yeah, absolutely.
Press this within the next 48 hours. Keep a copy of that letter for yourself. And then once that deadline comes, if you haven't heard from your landlord, you can go to the general district court. You can pull the form off the online court system. It's called a tenant's assertion form. And you would file that and have a copy of your letter, and you can ask the judge for all sorts of things, including asking the judge to order the landlord to make these repairs, asking the judge to give you a rent abatement. In other words, you can say to the judge, look, I lived with this situation for 2 weeks, 3 weeks, however long it was, and I didn't get what I was promised I would get in the lease, right? Because in the lease, what the landlord's promising you is that he'll provide you with a safe, healthy, habitable place to live. So if he hasn't done that, he's breached his responsibility, and you can ask that you get some of your rent back. There is a catch to the tenant's assertion, which is unfortunate and something we hope to work on in some of the upcoming years. And that is that in order to file a tenant's assertion in court, you have to
earn rent.
And then you will be paying rent into court, into what they call a court escrow account, until the judge decides the case. Because you could say, I want out of the lease. The judge could let you out of the lease. You can also say, I want that abatement in rent. So the judge would give you all or part of the rent that you paid into court back. The judge could order the landlord to take the money you paid into court and actually fix the property. But there is that, what we think of as a barrier that we'd like to see removed to filing that tenant's assertion, in that right now the law requires you to be up to date on your rent.
And Christy, I put in the chat for everyone's benefit too, Senate Bill 905
Yes.
that just passed this year that also kind of helps with that. So if you want to take a look at that and see if that applies to your situation, you may be able to, after going through a few steps, if it's not fixed, you may be able to take it out of the next month's rent up to $1,500 in order to get it fixed.
That's
So
right.
take a look at that and see if that fits for your situation as well.
That's right. Thank you for pointing that out.
Were there any other questions? We have, I think we've touched on a lot, and I know that there's some that we've connected with you individually in the messages because it may be more of an individual situation. I know there's one question that we need to get back with you, a little bit more information. We've taken stock of that. I'm sorry, I just saw one come up. Go on, Christy.
I actually read the one that just came up, and the question has to do with people being in month-to-month leases and whether or not the normal 30-day notice and then you have to move out applies during the pandemic. And unfortunately, we don't have anything in place, nor does the CARES Act provide anything that would prohibit a landlord in a month-to-month situation from just giving 30 days notice and saying you've got to move out of this place after 30 days. It's a really good point. It's a really difficult situation. But I can't think of anything that would change that right now.
And I just want to point out a few different resources that you can go to if there's any questions we haven't answered or want to answer the next, remainder of our time. The first, if you're experiencing eviction, you can call the Eviction Legal Helpline. That's 1-833-NO-EVICT. We're there to give brief advice, explain the process, help walk through your options. And if it ends up being a situation where you really need to have an attorney there with you in court, we'll refer you directly to the local legal aid program if you're income eligible. The other is that rent and mortgage relief program that I referred to earlier. This is a website where you can go to learn about the program to see if you're eligible for rent relief funds. I encourage everyone, if you have fallen behind on rent, access this as soon as possible. There's a limited pot of funds, and it's not going to stick around forever. Hopefully Congress will act to send more money to the states to help with this, because we understand, renters and landlords alike are really hurting right now. But don't wait to take advantage of this. The other is our website, vplc.org. If you visit that homepage, there'll be an orange button called COVID resources, and there's a whole bunch of information out there to help people. There's information in housing. That's where you can find information about that tenant's assertion, information about what to do if your landlord is illegally evicting you, also information about public benefits, healthcare, and other things related to COVID to help you right now. And the last is the Legal Aid Society of Eastern Virginia. This is your local legal aid program. Their intake phone number is 757-827-5078. So if you're interested in getting help, whether it's housing or some other civil legal matter, they can help you. It is income limited, so only serving low-income people. Their office hours are limited right now, so the best way to go ahead and start that process is to call that phone number. Now, if you are another service provider and you want to make a direct referral, you can just fax over that paperwork to their fax number, which is 757-627-7583. That way, the tenant's not having to fill out things with your program and with legal aid. It's easier to just do that direct transfer. You can also try their online intake system, which is that bottom link right there, lasiva.caseworks.com/app. If you have access to the internet and you don't want to do it over the phone, you can do it online. Their website also has a lot of really other helpful information and more information about local options to assist you if you have any issues.
And so while you all are potentially thinking about any additional questions, I wanted to add a few comments to this. If your reaction to this is thank you for this information, but you're also frustrated, I do want to let you know that there's no one that has spoken to you tonight that thinks that any of the information that we have presented is overhauling the system and that there are just answers to all of your questions. What tonight was really about was to let you know that some progress, again, has been made and that there are some resources with stipulations, but there are some resources. I want to bring your attention to the fact that the General Assembly has been called into special session. We will be in this building on August 18th. And a lot of the COVID related, or somewhere close to it, because hopefully it is not the House room, because I need my 6 feet for this pandemic we're still in. But we're meeting nonetheless. COVID, emergency situations coming from the COVID pandemic should be within the realm of possibilities of what we're going to speak on. And so I'm working with the Virginia Poverty Law Center and other advocacy organizations for bills that will help us get to some more solutions for the immediate problems that we're hearing about based on the pandemic, but also some solutions that will help even after the pandemic is done and gone. But an overhaul of the system and some of the more systemic issues that are happening, that will take some more time. So we have the 2021 session in January, where we'll have even more legislation that we'll be putting forward. But I tell you that to say, it's really important that I hear from you if I'm your delegate, or if your delegate is someone else, or your senator, because this legislation that we're putting forward really gets stronger with more input that we have from the lived experiences of Virginians across the Commonwealth. The second thing is to let you know that you can't ease up off being engaged, because it is a year-long process. This is not just about voting. This is about the things and the entry points where you can be a part of this process. Every single step that we're going to have in special session has public input and public comment. Hopefully it will be electronic, but whatever it is, whoever your delegate is should be hearing from you if there is a situation like I spoke of at the beginning of the month, the beginning of the meeting. Some of the things that I'm working on come directly from calls that I've gotten from constituents. The problems that Christy and her team are trying to help us solve through legislation, when we're talking out some things about what solutions would be, it shouldn't just be us in a room. I am a renter, but my experience may not be your experience. So we need those experiences to give us input to make the bills that we're putting forward even stronger. And I also wanted to mention that a lot of what I have been discussing has been from the gaze of legislation. And so that's the legislative branch. There's also the executive branch and the judiciary branch. There need to be some significant changes in all three branches. I know that you all have reached out to me asking for a rent or eviction moratorium to be extended because a lot of this y'all need time to sort out. Some folks haven't gotten the unemployment benefits that they may be due. And so if there's a backlog in you getting your unemployment and you're supposed to use your unemployment to pay your rent, it would make sense for us not to evict you for your not receiving payment from a governmental system within the same executive branch. So I want you to hear that I understand that, but I can't fix that. As far as an eviction moratorium right now would have to be through the courts or through the executive branch. So when we send our follow-up email, we'll give you more information on where you can voice your concerns about that. There's some real piecemeal sort of situations going on. I see we have City Councilman David Jenkins with us from the city of Newport News. Well, he's very familiar with Pear Avenue, and that is a street that splits Newport News and Hampton. The way that the courts are acting, it's very possible for you to live across the street from someone. And if you all are going through the similar situation, depending upon which court you end up with, you may get a different situation. There are some courts in Northern Virginia that are choosing to not move forward with eviction proceedings due to non-payment because of the pandemic. And then there's some courts that are moving forward with it. There were, this piecemeal situation is the reason why I joined with 11 other delegates to ask the Attorney General for an opinion. And his opinion gave out more information on the CARES Act, which unfortunately does expire soon, but how House Bill 340 that we discussed, how that can be used to your benefit, but also listed out what the judiciary and executive branches can be doing to help keep people in their homes. The last thing that I will say is advocacy on the federal level. What Christy was saying about more money being needed. When I go to Richmond for the special session, we are looking at potentially $1 billion missing from our state budget. So it's very hard to ask for, you know, I think some estimates were that we needed like 200 million in this $50 million program. So if I'm gonna ask for another 150 million, that's very hard when we're already trying to find out where we're gonna cut or come up with answers to $1 billion hole. We are not alone in this situation. Other states are going through the exact same thing, but what is helpful is the HEROES Act that has already passed with the House of Representatives, that the Senate has been coming up with their version of an answer, and so there'll be some negotiation, but it is impossible for us to move forward with this without federal funding. And so if you're interested in doing some advocacy on the federal level, I can help you with that. Everybody has the same 2 United States Senators, Kane and Warner, and then based on where you live, whoever your congressional representative is, we can help you reach out to them. But it sounds like the majority of the Virginia delegation understands that there's no way to open schools safely. There's no way for us to have childcare. There's no way for us to keep you in your home safely without federal funding. And that is not an excuse, that is just the fact. So this is gonna have to be that, but then there's also the local government where, you know, here in Newport News, there's a program that's coming out next week. And so I do need to know if you did not put in your city at your registration. If you live in Newport News, we'll try to get you more information about that rent relief program that's going into effect so that you can apply for that. If you live in a different area, we can try and help you get more information about what's available in that area as well. So all of that to say that this is our attempt to give you more information with a full understanding. Systems are broken, but evictions are violent, and evictions during a pandemic are just, to me, unconscionable. So we're just trying to get you all of the information that you need to get to stay in your homes. I have not seen any further questions in the chat, so I'm gonna assume that any questions that you have, you've taken down our contact information, or that you'll be expecting the follow-up email. I'm seeing some heads nod, okay? You'll see the follow-up email that will be coming your way. There's a little bit more information that I got tonight that I wanna add, so I'm gonna say if you can give me till morning for us to compile all of that information so that it's one good comprehensive email, and then feel free to, the recording of this will be connected to that. Feel free to spread this far and wide to anyone that you know that lives in Virginia. The only thing that would change is the Legal Aid Society contact information might be a little different if they don't live in the area where we're representing. But I just want to thank Christy and Laura and Daryl, not just for what you've done this evening and walking us through some pretty complex concepts. It makes me want to go to law school to try and figure out some of this, and I'm a delegate writing some of these laws. But, right, Daryl, I do not need any more student loans. But to really give you some more information, I want to thank them for being here, and thank you for what it is that you do on a daily basis. I'll even be talking with them tomorrow about one of the bills that we're working together on for legislation. Also want to thank, as always, my Chief of Staff, Tempest Boone, for her help. Unfortunately, she hasn't been able to work on much else other than calls about employment and the lack of employment that's been getting to folks. If you have a case, or if you need help walking through getting your unemployment, or at least getting an answer about your unemployment, please reach out to us. We will add you to, unfortunately, the chorus of voices that are going through that. But we are continuing to try to fight, you know, to make sure that the executive branch is doing everything that they can to help you all. So we didn't go too much over an hour, but thank you all so much for sticking with us. And then if you pop up with a question tomorrow and you're like, oh, I should have asked it, please ask your questions and get the answers that you need. Thank you so much. Thank you for being here and for being a part of this.
Thank you so much.
Thank you, Delia.
Awesome. Have a good evening.